Let me go ahead and share my screen. And let's see if I can get it in the full. Okay, so today we are talking about implementation of engrossed substitute Senate Bill 5403, limiting financial interest agreements for licensed cannabis retailers. And today is the second of two stakeholder sessions. We had one yesterday afternoon. And I'm Denise Laflamme. I'm a policy and rules coordinator here at LCB. And there's our rules email for sending us questions and comments related to this rulemaking. So our objective today is to inform and obtain public feedback on draft rule concepts and language being developed around implementation of engrossed substitute Senate Bill 5403, which relates to financial interest agreements for cannabis retailers. So a few housekeeping notes before we start. You may have already heard we are recording these sessions, yesterday's session and today's session, and recordings are subject to public disclosure, just so you're aware. We also record these just so that we are sure that we have a record of all the feedback that we hear from you. While the Teams chat is going to be on today, we just wanted to let you know that any questions or comments you put in the chat are also going to be saved in our rulemaking file and are subject to public disclosure. Questions and comments that you put in the chat today, I may not be able to respond to them immediately, but we will try to look and address them by the end of today's session. Participants, you all are muted, and we will unmute you when you indicate that you'd like to speak, and you can do that by using the raise hand function, and then we'll go ahead and unmute you for your question or comment. And then again, here's our rules inbox. Email rules@lcb.wa.gov. That goes to all of us in the rules team at LCB. So what are we covering today? So one thing I'm having an issue with here is I cannot see the chat. So I have this new computer. I have all my screen set up, and now I've lost visibility of the chat. So maybe as we move forward, if Kevin or Tierney, if you see anything in the chat, if you could let me know, that would be great. Sorry about that. What we will cover today is we're going to just review the legislation. We're going to talk about the rulemaking process and timeline and where we are in the process. We want to go over our draft rule key concepts that we've included in the draft for discussion that was posted, and go over some of the draft language that we have in that discussion draft, and then hear your questions and comments. So engrossed substitute Senate Bill 5403 was passed during the most recent state legislature session. It amends 6950, 325, Section 3 related to cannabis retailers' licenses. This new law takes effect January 1st, 2026. And the law also applies retroactively to any agreements that are in place at the effective date, and then prospectively on or after effective date. So this is the existing language. It's a new subsection 1 with the bill. Any individual retail licensee and all other persons or entities with a financial interest or other ownership interest in the business operating under the license are limited in the aggregate to holding a collective total of not more than 5 retail cannabis licenses. And so this is the new subsection 3B2. That was added, a retail licensee and all other persons or entities with a financial or other ownership interest may not enter into any management agreement under RCW 6950-331 or any agreement as referenced in RCW 6950-395, whether or not in exchange for payment that confers a financial interest across more than 5 cannabis licenses. And then the legislation goes on to define financial interest. And it includes any sharing of profits or revenue, any assistance, coordination, or recommendation for the purchase of cannabis products, whereupon pricing is coordinated or discounted, the common use of intellectual property assets, any operational control over the business or operational support for typical day-to-day business operations, any sharing or coordination of marketing and advertising efforts and expenses, and any coordinated sharing of employment or hiring decisions, including the shared employment of individuals. So why are we doing rulemaking? Rulemaking is needed to align our existing LCB rules with the new statutory requirements. It is also needed to clarify any ambiguity in the law. And then we are also looking to address related stakeholder concerns, including those raised in recent rulemaking petitions submitted to LCB within the same WAC sections that we have open for this rulemaking. So where are we in rulemaking? As you know, rulemaking is a process, and the CR 101 to initiate rulemaking was filed on July 23rd of this year. It was published in the Washington State Register. An informal comment period ended on September 5th. We've received quite a few comments, and we thank you for that. The draft rule language that we're talking about today was posted on October 20th, and we are currently holding the stakeholder sessions, one yesterday and one today. And if you were not in attendance yesterday, we're going over the same material that we presented yesterday. So it's the same slide deck and information. So going forward, we're going to conduct additional stakeholder sessions as needed, depending on feedback that we get. In winter 2026, we plan to request board approval for the CR 102, and the CR 102 would contain the proposed rulemaking language. So we're working with stakeholders now so that we have a solid proposed rule language when we file the CR 102. That is published in the Washington State Register, and then we will hold a public hearing after that to gather official comments on the proposed rule language. And then in early spring 2026, we anticipate filing the CR 103 with the final rule language, with the final rule, and rules would become effective 31 days after that filing. So that's the process. So today I'm going to be talking about the amended rule language that affect 5 different WAC sections. 314, 55018, 035, 050, 079, and 087. And so this is just a summary of the WAC sections that we're going to go through. I'm going to try one thing before we go into this, just so I can hopefully see a little bit better. If you don't mind, I'm going to not do the full presentation view, because then I can see chat information. So sorry, I'm gonna just switch it up here. Hopefully you can still see those slides okay. If not, you can let me know in the chat now that I can see the chat. So continuing on, let's just start with 314.55.018. The concept, so all of these changes are highlighted initially with the concept that we're trying to address with the rule language, and then presenting the draft or the rule language that we have in there in the discussion draft. So for the first one, the concept here is just to clarify the 5 retail store limit, just to add some language to call that out. And the new language that we have in there is underlined. It includes any agreement, written or otherwise. And then we added for up to 5 retail stores owned and operated by one licensee, just to highlight that restriction. Okay, let's see. Okay, the next changes that we're looking at are around the concept of preferential pricing being prohibited. This is a new section 2. Can I share why? Oh, see, I can read the chat now. And we have a question from Charlotte. Might as well answer that because we're starting. So the rule language we have in here is still in flux. You know, we're trying to work out some specifics and work out how to have the rule language clear. But today we're really trying to focus on some of the concepts that we're hoping to include and get your feedback on. So the rule language is not perfect, and we're even after yesterday's discussion, there were some questions about, you know, clarity, making the language more clear. So it'd be helpful today to focus on what concepts we're hoping to include in there, and then we're going to try to develop more clear and more streamlined language. So we knew that the language wasn't perfect, that we're still working on some things, but we'd also like to know what are the most important concepts, or what is your feedback on some of these concepts. So that's why I'm talking about concepts. So hopefully that gives you a little bit of background on that. So this concept, preferential pricing, is prohibited. So the language that we have in there for discussion is adding any cannabis products sold by a producer or processor to a cannabis retailer must be made available and sold under the same basic terms and conditions per purchased amount to all retailers on a statewide basis. And this is additional subsets of this include preferential pricing that includes offering different prices for the same amount of product to different retailers shall be considered a prohibited practice. Consignment sales are prohibited. Rebates to retailers are prohibited. The next language that we have, it addresses the concept of exclusivity agreements, including white labeling or private labeling, is prohibited. So we're trying to develop language around that concept. And the language we have in there now is in the draft is any and all exclusivity agreements are prohibited, including white labeling or private labeling that result in products not being available to all retailers. For purposes of this section, white labeling or private labeling means cannabis products sold by retailers with their own retail branding and logo. The next concept under 314.55.018 is around cannabis retailers must be under the same ownership to negotiate collectively for lower product prices. So we have a new subsection 4, multiple cannabis retail licenses not under the same ownership may not commit to purchasing or purchase products collectively to negotiate a lower price. And we have a question here from Gregory Foster. Does this include brands which are only sold in one retailer, not just with the retailer's brand? I am not sure. This concept relates to it's the retailer's brand, so that's my understanding. But if anyone wants to add that, but thank you for putting that question in there. Clearly, we're not the language we have in there maybe is not clear enough to address that particular situation. So going okay on 4. This concept, cannabis retailers must be under the same ownership to negotiate collectively for lower product prices. The new subsection, multiple cannabis retail licenses not under the same ownership may not commit to purchasing or purchase products collectively to negotiate a lower product price. Moving on to the next new subsection 5. This is around exclusionary practices being prohibited and that there are penalties. So, I see we have some good questions in here in the chat. Thank you for putting that in there. So maybe I will finish going through this section and then we'll look at the questions that are coming up from this section. So if that's okay with you guys, we'll do that. We'll finish 314-55018 and then I'll swing back here and look at the comments in the chat. So under subsection 5, the language we have in there is any sales from a producer or processor to a retailer must not be coordinated or agreed upon in writing or otherwise to exclude any other retailer's ability or opportunity to purchase any product from the producer or processor. Exclusionary agreements between a producer or processor and a retailer, or the practice of excluding a licensee from purchase and sales, will be considered a prohibited practice. Any violation of this subsection will be considered a Category 4 violation pursuant to WAC 314-55-523. Except penalties will include license cancellation or a second offense for both the producer or processor and retail licensees involved. Continuing on under WAC 314-55-018, this draft language is around the concept of quantity discounts on cannabis products being prohibited under certain conditions. The new subsection 6, no cannabis producer or processor shall provide quantity discounts and no retailer shall receive quantity discounts on products that are negotiated for more than 5 cannabis retail locations. All locations up to the limit of 5 must be owned and operated by the same cannabis retail licensee. For any combination of more than 5 licenses at any time, for multiple independent licensees at any time, or based on a total volume or amount purchased over time, including conditional sales of products. Pursuant to WAC 314-55-017. The next concept that we have as part of draft rule language under 018 is including that agreements under RCW 6950-395 must not include activities associated with operational support of more than 5 retail licenses. And the language is agreements under RCW 6950-395 must not include assisting with or advising on the day-to-day operations of the business across more than 5 retail licenses. Okay, so that wraps up amended language in 018. The next section is 035, qualifying for a cannabis license. So let's go ahead and look at some of the chat comments around 018. Just so we can look at those. Sean put in that Kirkland brand is Costco, Safeway is okay. If the intent is not to allow stores to have their own brands, the rule needs to confirm trade names representing a store are not also allowed. Okay. Thank you for that comment. Isn't that still conditional pricing? Sorry, I didn't see when that came in, which section we were talking about. A comment from Paul, tough to address because PNP usually at some time will offer exclusive drops, limited quantity. This could be used often as a go-around. Okay, thanks for that comment. And oh, good. So the commenter put in some more language. Need to add verbally, this contradicts negotiating for 5 stores. If you have 5 stores, you are allowed to negotiate lower prices. Then the next rule states you cannot. Oh, yes. Okay. Thank you for calling that out. Clearly, we need to clarify that. And that is in section. Okay, thank you. Okay, thank you for that comment. You aren't currently allowed to negotiate lower prices for 5 stores in the current laws regulations. There is no regulation, so that term is misleading. If you want to put a little bit of clarification in the chat so that we can make sure that we follow your comments into what sections we're talking about. Okay, there's Shay's gonna give us some comments. Okay, that would be great. Any additional comments that you provide to us in writing would be really helpful. Then we can track exactly what language is confusing or is not clear. That would really be helpful. Yes, thank you, Caitlin. That's what I'm after each section. So maybe after each slide. Is that what you're suggesting, Caitlin? Or each section? Okay. So I'm going to move on and then maybe ask for comments after each slide. So that's each subsection. Subsection 2 stating producer processor needs to make all product available to all stores statewide isn't feasible. Okay, after each slide. Yeah, thank you, Caitlin. For a small producer processor, they do not have the ability to offer products statewide. Yes, these are comments from Amber. Thank you for putting that in your comment in there, Amber. We have received comments to that effect from others, so it's something that we have to look at in terms of the language that we have in there. Okay, so we are heading into, thank you for putting information in the chat. I appreciate that. Like I said, we're keeping the chat record and it's very helpful for us to go back to look at for reference. So let's move on to WAC 314-55035. The concept here is, so this section is around qualifying for cannabis license. And the concept person or entity replaces married couple and adds a restriction for having a financial interest. We have removed the married couple language, although after comments yesterday and further discussion, it seems that we have to amend this and have the married couple restriction somewhere, either in this portion of this section or at another place under industry member or member that we have existing in WAC. So there was a question yesterday about if we are saying that each person in a married couple can have up to 5 retail licenses, and our intent is to not allow that. So, but we are aligning the language in this section. No person or entity may have a financial interest or be a true party of interest in more than 5 retail cannabis licenses. That lines up with the language in the legislation. And we also just call out that any industry member may not be a true party of interest in a certified cannabis testing laboratory, as this restriction exists. So I see a question in chat. Since producers cannot sell to a retailer, the reference to producers throughout the document should be removed. A novice may be confused by that term being included. Okay, thank you. We will look at that issue. Thank you, Sean. Do we have any? Oh, we have a hand up. Tierney, would you go ahead and unmute Sean for us?
Sean, you should be able to unmute yourself now.
There we go. Okay. Since we live in a world where our names are represented by numbers, I think a good idea would be to include that no person, entity, common social security number, common UBI number, nor common federal tax ID number should be associated with more than 5 retail stores.
Okay, thank you for that. Okay, I'm writing that down. Thank you. Okay, let's move on. Okay, the next concept that we're looking at is licenses must not share employees across more than 5 retail locations. And the language we have is a cannabis retailer license must not share employees across more than 5 retail licenses. This includes shared hiring, management, or coordination of employees. What we're trying to allow, and this came up at our discussion yesterday, is that if there are part-time employees at different retail locations and they are not owned by the same owners, that those employees would be able to work part-time at different locations if they're not under the same ownership. So we're trying to allow that to accommodate workers who have different part-time jobs. So just if you have suggestions around that language, that would be helpful. Okay, I see there's another comment in the chat from Amber regarding subsection 2, the married couple portion being removed should remain. Yes, keeping that language is archaic. I think requiring a married couple to have their licenses separated contractually is reasonable, but a married couple shouldn't be considered one person, as not all married couples have combined finances, assets, etc. This section could easily be circumvented by divorce or not getting married, but acting as a married couple. Okay, thank you for putting that comment in the chat. Shay has their hand up. Would you mind unmuting Shay for us, Tierney?
Yep, Shay, you should be good to go.
Hello, in section 1, there's a sentence that says the rule shall not be construed as prohibiting placing orders, blah, 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 for up to 5 retail stores owned and operated by one licensee. WCLA's memberships pointed out that that should probably be licensees because many stores are owned by multiple partners.
Right.
And it being singular could be construed as not being able to allow that business partners.
Great. That's okay. Thank you. And I have one more comment. Married couples should use what they claim on their taxes. Okay, thank you. So moving on, section 3, no person may be paid wages from one entity for work at a separate agency. Okay, thank you. There's some suggested language. Thank you. Appreciate that. Okay, moving on to a new subsection 4. The concept here is sharing or coordination of activities that support business operations must not involve more than 5 retail licenses. And so the language that we have in there currently in the draft is the sharing or coordination of activities or resources that support day-to-day business operations must not involve more than 5 retail licenses. And for this part, we try to flesh out what some of those activities might include, such as facility maintenance contracts, security services, ordering products or supplies, paying vendors, marketing and advertising efforts as part of activities that support day-to-day business operations. So again, there's thoughts on specific activities that would be good to spell out there. We'd be open to that, of course. And then moving on, this new subsection 5, the concept here is having an ownership or financial interest is limited to 5 retail licenses. This is spelling out this requirement, and no person or entity shall have an ownership or financial interest in more than 5 retail licenses. And this is adding in the language of financial interest that is defined in the new legislation. Back here, there's a question here from Gregory Foster. Is this an exclusive list? This includes assisting with, so recommending a service is including, so it's not exhaustive. But clearly we could address some additional tweaking there to make that more clear, but not limited to, yes. Let's see. So moving on. The concept here, this is there's some renumbering here, and yeah, the old 3A has become the new 6A for this section, and the concept here is expanding the definition of control for qualifying as a true party of interest, and also clarifying employees and service providers are not included as being true parties of interest. So the language here is expanded. You can see the old language here. The control means that you can see the strikeout portion of that. And this new language is any person or entity who exercises any operational control over the business, including directing the operations or management of the business, qualifies as a true party of interest. This includes activities associated with directing core or day-to-day business executive functions. And again, we include some examples of the activities that could be classified under operational control, such as forecasting and managing costs, establishing staffing and hiring targets, establishing workplace and other business practices and policies, planning and executing marketing and advertising efforts, and approving and authorizing payments. I'm just looking at the comments. I was thinking we were going to have some comments on that. Can two different retailers collaborate in ad creation and publication of the ad without violating the marketing rule? Well, we can look at that question in language just to clarify that. Section 6A qualifies as a TPI even if not named on the license. Okay. Okay, thank you for the comments that are put in. So continuing on under concepts under 035, the next concept that we're looking at is defining financial interests to align with the statute. Here we have financial interest means, and this is a new section C, 6C, financial interest means the sharing or coordination of activities or resources. This language is primarily from the new legislation. We put in some additional language to help clarify. And all of these elements are from the bill. Any sharing or receiving of profits or revenue, or the rights to receive profits or revenue, that's some additional clarifying language. Any assisting or negotiating, recommending the purchase of cannabis products, planning or executing or directing the use of intellectual property, assets, providing any control over business operations, any sharing or coordination of activities or resources that support day-to-day business operations, any sharing or coordination of marketing. Oops, I'm going to take a little break here and just have a quick sip of water. Oops, sorry about that. Any sharing or coordination of marketing and advertising efforts or expenses, and any coordinated sharing of employees. Let's see. Do we have any comments on this section? Move on to the next one. The concept here is to clarify exceptions to being a true party of interest. We're renumbering some of the new sections. I think we have some other comments in the chat. Thank you for putting that in, Sean. Thank you for everyone who's putting in specific comments in the chat. The concept here is just to clarify exceptions to being a true party of interest. For purposes of this section, true party of interest does not include, and this is a non-exclusive list, a consultant receiving a flat or hourly rate compensation under any agreement, provided the consultant or consulting company does not exercise control or have a financial interest in more than 5 retail licenses. That's going back to definition of control that we've looking at amending, and then also financial interest that's defined. Any business or person with a contract agreement for services with a licensed business, such as branding or staffing, Company will not be considered a true party of interest as long as the business or person does not exercise control or have a financial interest across more than 5 retail licenses. And here's another place that we're looking at adding language around individual employees who maybe work for different businesses who are owned by different owners, so that they can work part-time at different locations under different ownership. So that's another place. F needs to add verbally. Okay, so this is under, okay. Verbally as in terms of an agreement, so any agreement. So verbal agreement, I'm assuming that's what the comment is relating to. Yes. Okay, moving on. Thank you for putting that in there. The next this is somebody unmuted?
Someone
Okay.
came off mute, but I fixed it.
Oh, okay. Okay. Thank you, Tierney. Sorry about that. The next, so that was the end of amended language that we're considering under 035. Now we're moving into a new section. This is 314-55050. And let's see, I have one more comment in here. Retailers collaborating in shared marketing shows community collaboration instead of price wars, which is not helping the cannabis industry at all. Retail collaboration is now becoming against the law. Okay, thank you for putting that comment in there. Something we can consider moving forward. So we're going to go into 314-55050. This is the section that looks at including withdrawal, denial, suspension, or cancellation of a cannabis license. And the concept here is, oh, I see we have someone with the raised hand, Paul. Tierney, could you unmute Paul for us?
Yep, Paul, you should be able to unmute yourself now.
Can you hear me?
Sure
Yes.
can.
Thanks, Paul.
Hi, Paul Bryce. Before we move on, I'm not sure what the next section is, but I just want to address the elephant in the room. Push 21 is buying more and more stores. I keep hearing if there's any influence or ownership across, just being in real estate for so long, you want to sell your house to someone else, a sibling or a family member, they make you disclose that, and it's just not allowed for like tax reasons and everything else. Something has to be similar to this industry here. To sit there and think you can just find family members and just keep doing the same thing and increasing your leverage or your influence, there's really no difference. And the same thing needs to be said about in the future. If corporations get in here, I always say there needs to be like a second tier to this, where if there is any commingling, maybe the new number's 15 stores, that there is something commingled where you'll actually have a real penalty for crossing that allowance, and where there's going to be some true form of penalty. But to keep allowing for Push 21 or anyone else to then keep buying more stores and just having a family member so close and think that that's not influence is absurd. That's it.
Thank you, Paul. We have one other comment around how would enforcement work? Will the LCB review licenses and relationships once this is in effect, or will investigating happen based off reporting? Yeah, that's something we're considering. The LCB can see the monopolization, they just haven't stopped it. This is another comment. And where would the licenses go? Okay. And can you elaborate on that question? Where would the licenses go? Okay. So there's just some discussion in the chat. Thank you for putting that in there. Hopefully, we're looking for a response from me on that one. Let's see. So we are in section 314-55050. The concept, include any ownership or financial interest in more than 5 licenses as a reason for suspension. So the current one is the board has the discretion to withdraw, deny, suspend, or cancel a cannabis license application or license consistent with RCW 69331 for reasons including but not limited to, and this was a new subsection added, owning, operating, or having a financial interest in more than 5 cannabis locations. And then moving on, would they go to the social equity applicants, title certificate holders? I am not sure about that question. What would happen there? But thank you for putting it in there as for us to consider it. Goes to social equity. Okay. The next concept we have here is so that was the only change in 050. Now we're moving on to 314-55079, cannabis retailer license privileges, requirements, and fees. The concept is to clarify and align retail cannabis license requirements with statute. Amending subsection 3, any entity or principals within any entity are limited to owning, operating, or having a financial interest in no more than 5 retail cannabis licenses. Again, adding reference back to the new definition of financial interest as part of the statute. Amending 9, a cannabis retailer may not sell lockable boxes for less than the cost of acquisition or sell boxes received as a donation. The donation of lockable boxes must come from a person or entity that is not considered a true party of interest by definition of this rule. And then amending 11, a cannabis retailer may transport product to other locations owned by the licensee or to return product to a cannabis processor as outlined under 085. Okay, it seems like we're having some interaction in the chat, so I'm going to go ahead and move forward. We have Emerald City Collective with their hand raised. Tierney, can you go ahead and unmute them?
Yep, Emerald City Collective, you should be able to unmute yourself now.
Yes, thank you. Good morning. Mike Asai with Emerald City Collective and Black Excellence in Cannabis. I just wanted to just clarify that question. Any licenses that are suspended or revoked do go back into the pot for social equity until 2032. So I just wanted that question or that comment to be just basically be cleared up. And I will say this, unfortunately, because of the monopolization and what's been going on with the corruption within this industry the past 10 years is a reason Senate Bill 5403 had to come about. LCB is truly just has not been doing their job. And, I'm not sure where Director Lucella is in this meeting, if he's listening in, but there should be more staff here. We appreciate what you're doing. I forget what your name is, ma'am. But I just want to make that comment, let it be known that the corruption is thick and it's there and everybody sees it, and it's time to put a stop to it. So if in this rulemaking, my last comment, I will say that LCB should be leery of those who are signed in today that have 5+ stores that have 10 plus stores, those that are writing comments in, should be leery of anything that they say in particular to this rulemaking because they've already cheated the system. Thank you.
Thank you for your comment and clarification. Let's move on. Going into WAC 314-55087. This is the last section that we have any amended language in currently. It's around record-keeping requirements for cannabis licensees. The concept here is to include purchase agreements and services for inspection, and just amending language under 1A, purchase that of records that must be kept and maintained for a 5-year period and made available to the LCB include purchase invoices, purchase agreements, to include items and services purchased, from whom the items and services were purchased, and the date of purchase. So just adding some additional record keeping requirements. So that is where we are through all of the amended language we had in the draft for discussion. Does anyone else have any comments they'd like to provide? Oh, go ahead, Caitlin. Tierney, would you mind unmuting Caitlin for us?
Caitlin, you should be able to unmute.
Okay, good morning. Apologies, I had a hard time typing there. So I want to echo a lot of the comments that were made yesterday and today. I think, we all know why we're here, and that's that there has existed a conflict between the 5-store limit and management agreements for a really long time that has allowed some sort of fairly large retail conglomerates to rise up. And since the passage of 5403, we've seen those conglomerates sort of handle it differently. If the intent here is to sort of curb coercive contracts and protect our small businesses, we're all fairly small businesses here. We're seeing in particular one chain, but I think there's a few others that are actually buying as some over 5-store groups are divesting themselves of some of their stores to get into that 5-store limit. There are others that are then buying those up and actually grabbing more market share and creating more undue influence on the marketplace. And so while we do, as the Cannabis Alliance, have some very specific recommendations that we'll submit to you in writing, Denise, would love to hear you talk a little bit more, again, since this is just conceptual, about why you wanted to include things that aren't necessarily in 5403. I'll be honest, we have some concerns about the scope of this rulemaking and if it is appropriate with some of the language regarding white labeling and negotiating, and just want to make sure that we're following the rules so that then they can be enforced properly. If you could talk a little bit more about the ideas behind that. And then what is the plan moving forward on the enforcement side of things? No rules are any more effective than their ability to be enforced. What do you perceive are those mechanisms? We know what the penalties are, but what is the mechanism of enforcement moving forward?
Thanks, Caitlin. So the white labeling and that particular concept, that's really come out from a lot of comments that we've heard, including from recent petitions related to that. And that section we have open as part of this rulemaking, and we are looking at including some of those concerns in this rulemaking. I mean, submit your comments related to that, including those in this rulemaking. So it's just, that's the section that we had open, and these are some pretty fresh comments that we've been receiving from at least 2 petitioners, as well as other licensees. So that's what we're looking at currently. Oh, go ahead, Caitlin. Did you want to follow up with that? Do you mind unmuting her again, Tierney?
Yep, Caitlin, you should be good to go.
Yeah, I guess what we might recommend is that those sections, I think what I'm afraid of is that 5403 was really specific, and that we had hoped that rulemaking would then further clarify and sort of set out. Am I the only one hearing that alarm, by the way?
Yeah, I can't hear anything else.
Oh, all right. So sorry. Something's happening on my computer then. Okay, I'll just talk through it. And so by sort of adding these components in that were not a part of 5403 explicitly, I worry that we're not able to have those full discussions. And I think you saw some of that in the feedback here today, in particular around price negotiation and discounts and things, that there's still a really big need for clarity in that particular section there, and just want to make sure that it's not in conflict and how that's contemplated in other parts of the statute and WAC. And perhaps those might be worth their own rulemaking so that we could have a really explicit discussion about what that looks like, whether it's through management agreements, the 5-store limit, or just more broadly in general.
Okay, thank you. Thank you for that. And then your other part of your question initially was around enforcement. We do have some enforcement folks obviously working with us on this rulemaking. So thank you for that comment. And it is something that we'll have to discuss and look at moving forward in terms of how that will work.
Is there any appetite to discuss here? There's one chain that comes up in particular, and we actually just had an industry event earlier this week where I got to talk to quite a few stakeholders, and I'll just sort of share the anxiety that I'm hearing from folks that after all of the effort to pass this legislation and now this rulemaking effort, that it's not going to make a difference anyways, that these large chains are still going to find ways to get around it. The undue influence and market share is going to persist, which is then going to force everybody else to keep wholesale prices low. And we're going to continue to sort of see the disintegration of I-502 in Washington State. And I think a little bit more attention to that enforcement piece of it, I think would really have a big impact on how people are feeling about it, and then the actual efficacy of this law when it goes into effect.
Okay, thank you, Caitlin, for sharing that. Okay, I want to look back at some of the comments. There's some comments around the white labeling and private labeling. Have no real UBI that leads back to a business, and no UBI without traceability. So there's some comments about that. Vertical integration, yes, this is part of the white labeling discussion, is the relationships between retailers and the processors. Are there still title certificate holders? Okay, that is a little bit out of my area of expertise, but thank you for putting that in there. And okay, I think there's some internal discussion going on in the chats, not necessarily related to sending it my way. So I will continue on unless anyone else wants to raise their hand and come off mute and provide some verbal comments. Otherwise, I'll just go ahead and move on. Thank you for this discussion. This was it's just good to get all the different perspectives here. I see Emerald City Collective, you have your hand raised. Do you mind, Tierney, if you unmute them for us?
Yeah, thank you. I just wanted to just reiterate what I had thought about this before, what Caitlin had just said, that LCB, the law is the law, Senate Bill 5403, and LCB sometimes has a history of going outside of what that law is. And so just wanted to just reiterate that, just follow what the intentions of what the law is, and not arbitrarily and capricious just create something. That's all. Thank you.
Thank you. And some of the issues that we are looking at related to undue influence under 018 do specify around the 5 retail store limit. So there is that language in there, and that does relate to the legislation. So just trying to clarify some of the 5 store limit requirements. Okay, so next steps. We will continue collecting feedback. Again, welcome comments, written comments, follow-up comments to the rules at lcb.wa.gov email, which I'm putting in the chat. We're going to meet internally to follow up on today's and yesterday's session, talk about where we need to make changes, clarify language. And we will determine if we need additional stakeholder sessions to follow up. And we have one additional comment or hand up. Tierney, would you mind unmuting Sam, who has their hand up?
Sam, you should be able to unmute now.
Hi there. Yeah, speaking to all this with like the chains and discounts, and oversaturation of product, when I personally, as I view it, I look at it as an oversaturation of wholesale material in the market, which is a very large problem right now. Essentially, Washington is oversaturated on the amount of product they create for retailers. And so with that, it kind of creates like a systemic problem where retailers are forced to engage in discounts and sales program to attract customers to their stores. And so with that as well, too, it also engages the brand to work with their retail partners to drive brand acquisition and customer acquisition. When I really get down to it, I feel like that's one of the driving forces within the industry right now is just the oversaturation of product. And within that like whole model, the best companies and retailers that are going to succeed are the ones with the best sales models and practices. And so, we're talking about an oversaturation and a retail conglomeration of specifically people like Kush 21. For me, these people, it is an oversaturation. They're at a large amount of stores, and it creates, an undue burden to smaller retailers. I will give it that. But they have like worked within the model that was presented with them with their lawyers to also gain acquisition market share, which is, corporate business in its essence. That being said, it really stems back to, for me, a systemic problem, which goes back to an oversaturation of wholesale material available to retailers and producer processors, which create this sales dynamic that goes into it. And then here we are as well, too, adding a lot of new licenses to the mix, which also creates more competition and drives more. And so it's a cascading cycle, which for me personally is a systemic problem. And it is, to do with regulations that like fit at their core. But, the companies in the system, the best people that are going to succeed are the people that have the best and most advanced sales models and business practices. And so it's hard to really find undue burden on them for finding, a sales model and approach to business that work for them. So while I really agree that there's an oversaturation of retailers that create an undue burden on it, the other side of it is it's really hard to I don't know the exact word, but you know, it's hard to condemn them for working inside a business model that their lawyers and everybody presented to them that was a best fit for the industry. So I wanted to just mention that as it's, you know, I think it's a much larger thing than just discounts and product, and it's a systemic issue that goes into like legislation of product and available product and retail licenses throughout the state. So thanks for letting me say that.
Thank you. Thank you for that. Okay, and I'm just looking at the chat to see, looks like there's some interplay in the chat. Oh, Sam, did you want to add anything to that, Tierney? Do you mind unmuting Sam again?
No, Sam, you should be
Yeah,
able to
thanks.
unmute.
Yeah, thanks. So I also wanted to speak to like the white labeling as well too. That's something that was a topic for this as well too. You know, you really get back into the same like systemic issue that we talked about, which we have like an overabundance of product on the market. With the laws and legislations that are set up, you know, it is, you know, on the retailer, their choice to choose to onboard or, you know, sell your product or engage with your brand. The problem is with that is in, you know, a fiercely competitive market like we have, the store that's right next to the store that has the brand that, you know, they're trying to onboard or carry might not be interested in playing an aggressive price game with the store next to them. And so it really goes into that white labeling. I don't know why we are moving away from that, or if that is really the direction that, you know, but it offers an opportunity for, you know, an oversaturated market just to still have brand sales while, you know, being at multiple retail chains and not creating this fierce competition and discount war between them. So that's really when you get into the white labeling and how it's like beneficial for both the retail partner and the producer processor as well too, is because it allows opportunity and a decrease in this escalating sale war that we do in the industry right now. So I just wanted to speak to that as well.
Okay, thank you. Thank you for that perspective. I hadn't heard that put it that way before, so. Sean has their hand up. Tierney, would you mind unmuting Sean for us?
Sean, you should be
Hi.
good to go.
I'm a little concerned about the law goes into effect January 2026, right? January 1. Yet the
Yes.
rules aren't going to be out until sometime after spring of 2026. So what happens in that interim space? You know, because it could be easily 6 months between the time that the law goes into effect and the rules go into effect. How do you address that?
Well, the law goes into effect on the 1st of January. So what's in the law is what will take effect. The rules just will, you know, clarify some of the elements in the law and then, you know, put them in our rules, but the law will take effect January 1st.
And
So
so
all of those restrictions that are in there in the law take effect.
So will there be enforcement in that time then? Does the LCB have the authority to enforce that law before the rules come out?
We have authority to enforce the law, yes.
Okay,
I don't know if anyone in enforcement wants to speak to that, but it does take effect on January 1st, so.
okay, thank you. Yeah, I'd
Yeah.
love to hear from enforcement on that topic.
I don't know who we have today, but I don't know if anyone else wants to provide any commentary on that, but we did put out our licensing folks did put out a notice around the requirements of this new law also, and in that don't know if anyone wants to put that in the chat. That was sent out in a Gov delivery, just reiterating that the law does take effect January 1st. Let's see. When do you think we will get the next draft? Okay, let's go back up. Thank you for this. Please take a second look at marketing. Okay, thanks for putting that in there. When do we think we'll get the next draft? We'll go straight to CR 102. Thank you, Jeff. So at this point, I think there will be another draft circulated before we go to a CR 102. The idea is to have a pretty solid draft that we feel confident in for the proposed rulemaking submitted as part of the CR 102. So I don't know when we'll have another draft. Hopefully in the next few weeks, we are meeting with our rulemaking team to follow up on these sessions. And we'll look at what needs to be addressed in another draft. So and I would love to have another meeting like this to work through the changes. Okay, thank you for that comment. Some cannabis attorneys need consulted on what is the workaround. Okay, I'm not, as much as I hate to say it, more regulation, but LCB approves edible packaging. Maybe the LCB should approve all flour with multiple labels. Other commentary about commodity. Thank you, Desiree. She is my hero today, helping me with the camera and then also putting in the Gov delivery notice. So Desiree Monroy has put in the notice that went out Gov delivery from our licensing folks around this new law. And so the link is in the chat. And is there a deadline for further comment before the 102? We will send out, when we have another draft round, we would send out a Gov delivery and let people know the deadline that we would like to get comments back. But really, if you'd like to send in comments on this current draft right now, anytime, like I said, we are meeting with our internal team in the next week or so. So sending in comments now would be great. Any consideration given to requiring producers, processors to publish prices? Thank you for that comment. And we will look at that. So in the interim, starting June, the LCB can enforce the law based on their interpretation until they have rules in the spring. What about cannabis alliances that hold producer, processors, and retailers? Do they have to break up? We can look at that in terms of what are alliances. Okay, so moving on. Thank you for everyone's comments. This has been very helpful. We didn't get a ton of written comments in the chat yesterday, so we appreciate that. So our next steps, and some of these questions were coming up in the chat. So finalized draft rule language incorporating public feedback. So under the Meet with the LCB project team, decide whether additional stakeholder sessions are warranted. People are asking about this, so we're going to look at the feedback that we get and determine that, and we'll communicate a schedule and additional language that we have to share before CR 102 is filed. And then when we finalize draft rule language after we've incorporated feedback, that's when we would file the CR 102 with the official proposed rules. There would be a public hearing, and then the rule adoption would be filed as part of a CR 103. I'm going to put, let's see. Okay, I'm not doing a great job here, but Let's see. I'm going to put a couple things in the chat. Let's see. This is what I'm putting in the chat is a link to a survey. Just a quick few questions just about your experience today and a little bit about you and who you're representing. If you wouldn't mind taking a few moments to answer questions for our survey. We're just trying to get feedback to improve these stakeholder sessions. So I just put that in the chat. And also you can follow all of the information related to this rulemaking and other rulemaking if you go to our current rulemaking activity webpage, which I am also putting the link in there. That will give you the most up-to-date information about where we are in the process, drafts that we're sharing, previous drafts that we had. I'll post on that website. Also, the slides from today as well, I'll post up there so you can, if there's something you want to look back at, that would be great. And that's all I have here. So, okay, and did we have one other, did somebody else raise their hand here? Jessica, go ahead, Jessica. Tierney, do you mind unmuting Jessica for us?
Jessica, you should be able to unmute. Oh, go ahead.
Thank you. Yep, it is working. And thank you, Denise, for this session. I've attended both and we appreciate the space. I wanted to just clarify a question that I had dropped in the chat. I heard a yes, but it might have been a little light. And so I wanted to just get clarification. Just to clarify, in the interim, starting January 1st, the LCB can enforce the law based on y'all's interpretation until you have the rules in the spring. Is that correct?
Let's see if we have someone from our enforcement, which I'm not sure that we do. We had several folks from our enforcement group attend yesterday, and anyone want to comment on this question from the LCB side? Kevin?
Yeah, let me hop in here. Yes, so I'm Kevin Walter, the Policy and Rules Manager, and the plain language of the law applies January 1st, right? We don't have to have rules for anything unless the legislature explicitly says you have to do rules on a particular statute. So yes, that would apply. There was Desiree provided a link in here to a notification that went out to the industry back in September, and it has like a bulleted list of summarizing what the statute says. And so that's what they're going to be looking at. In terms of what mechanism our enforcement team is going to use to do that, I can't really speak to that. We could follow up with folks in enforcement. But rulemaking really is to kind of flesh out the more subtle nuances of a statute and provide clarity where there might be ambiguity. And kind of related to that, backing up a little bit to the comment that Caitlin made, I would say we recognize that the statute, the bill 5403, has a somewhat limited scope. But in initiating this rulemaking, we've heard from a lot of stakeholders, we've received petitions and emails and things, and there's a lot of kind of related issues, right, that come up anytime we hear about more than 5 stores. We hear about things like exclusionary agreements and that sort of thing, and they are part of the same rule set. And that's why we wanted to put out this discussion draft that includes a number of different concepts to get the conversation going with you all, which, there's been a pretty lively conversation today, and that's exactly what we were hoping for. And that helps us understand, what concerns exist among the industry so that we can appropriately apply the new statutory requirements under 5403. So the draft that we're looking at today, it's going to change. This is not static by any means or final by any means. We're continuing to listen to stakeholders, and we want you to send us any written feedback you have. I just want to underscore the fact that this is an iterative process, and you all are a part of that. And so we really appreciate the conversation. We will continue to reach out and notify everyone as the rule evolves and when we're ready to release the next draft. But to answer your initial question, yes, the LCB does have authority to enforce the statute starting January 1st, and will do so in some capacity.
And if I may, just to clarify that one step further, thank you for answering that and for being so expansive about it. That's very helpful because I truly believe that expectations early are clear and kind. And most of these rulemakings or the rules make them to us, get to us late. So you can only understand, right, what the antithesis of kind is when we get them. So that's really helpful. If you are going to be enforcing based on your interpretation, are you going to be laying out further what that does look like so that again, we have some sort of information about what that is going to look like for that interim?
Yeah, so again, we would have to take a pretty conservative interpretation just based on the plain language of the statute, right? And so that Gov delivery announcement that was linked here with the bulleted list says, summarizes what that plain language is. So I think that is the lens through which we're going to be looking at it. But again, beyond that, I would defer to our enforcement folks to clarify, how that would be enforced.
I appreciate that. I think getting it from the right corner is the right source. Is there a way that we can, is there an expected follow-up? How could we engage with that as a group, or could another notice be delivered so that we had information about that?
Yeah, following the stakeholder sessions, we're going to be meeting internally and talking with licensing and enforcement folks, to make sure that we're on the same page. I think that it's reasonable, that we could be putting out some sort of additional clarification in order to provide that for those that are going to be regulated and enforced as of January 1st.
Thank you.
Okay, thank you. Thanks, Kevin, for stepping in there. Unless there are any other questions or comments, again, thank you so much for joining us this morning and providing your comments and your questions that will help us moving forward. And if you have a few moments, please take our survey with the link in the chat. And we will see you next time, and we'll post any materials related to this rulemaking on our current rulemaking activity webpage and thanks so much.